and it directly benefits the child. That's what child support's supposed to do. It's supposed to get to the child. It also would keep funds here in Mississippi to benefit our local economy. 80% of TANF reimbursement payments right now, they go back to the federal government. And instead of sending that money back to Washington, if we are able to move forward with a full pass-through, that would keep those funds in Mississippi. Then they could be spent in their local communities. Obviously, a pass-through, every dollar that we pass through to a custodial parent helps reduce the level of poverty if they're living in poverty. And the pass-through then provides additional financial support to lift these families up out of dire poverty. And having a pass-through is an incentive. Knowing that a portion of your child support is going directly to your child, the non-custodial parent's going to have, more of a likelihood of paying the child support if they know it's getting to their child. And what happens, we're going to talk about our fatherhood initiative in a minute, but financial support from non-custodial parents, it just strengthens that parent-child relationship, and it contributes to a more positive experience when both parents are involved in that child's life. And this last point, I hope you'll keep this phrase in mind regarding a pass-through. More people pay, and people pay more when there's a pass-through. All of the states that have gone to a pass-through or a full pass-through have seen that more non-custodial parents pay some child support if there's a pass-through, and those that were already paying child support pay more when they learn that there's an actual pass-through. So with a pass-through, again, more people pay and people pay more to the benefit of their children. A couple of pieces of legislation we'll be proposing. We're actually coming back with these for about the third year, I guess, this year, hoping we can get these through to the finish line. Again, under that notion of trying to find every potential source of recovery for children. We're going to be proposing a gaming intercept law once again. We'll bring a bill. We've been meeting with the gaming industry about this, and I wouldn't say they're really excited about it, but they're not adamantly opposed to it, and I think they're going to work with us this year. Yes, ma'am, Madam Chairman.
We've done this for a couple of years, but remind me, many of our heavily gaming states have this in their laws as well already.
Essentially, the majority of the states that have casinos already have a pass-through. Our most immediate neighbor, Louisiana, has had it for several years, and they collected about $2.5 million last year through gaming intercept. What this would do is, when a parent wins, the child wins by getting part of those winnings. Now, our bill, as you'll see it when it's dropped, I think Senator Michelle is going to be sponsoring that bill again this year. It will apply to slot machines and to sports betting, I believe. Do we have any sports betting in there? Yeah. It doesn't apply to the table games because they don't generate, well, let me back up. It applies to slot machines because any winnings over $1,200, which is the level we're setting it at again, any winnings over $1,200 generates a requirement that the casino complete a 1099-G tax form. And so that will trigger the check with our child support arrearage database. And then sports betting is $1,200. $1,200 for that number? Yeah, okay. $1,200 in sports betting winnings, again, generates a requirement that the casino do a 1099-G. We already do an intercept with the state lottery, and we collect from lottery winnings already. Then the second bill we're going to bring to you again this year is an insurance match bill. This will allow child support to be deducted, so to speak, from insurance recoveries that non-custodial parents receive. So when a parent is paid an insurance recovery, the child gets part of that as child support. And it would allow us, there's already a federal program. There's a federal clearinghouse that the Federal Oversight Agency, the Office for Child Support Services, maintains a clearinghouse already. And we would just allow insurance companies to interface with that clearinghouse. We've been talking with the insurance industry. We're going to probably limit what this applies to personal injury recoveries, workers' comp recoveries, which we already received some funds from. What else am I leading? Auto liability recoveries. I'm familiar with, from my time, I was formerly, for a couple of years, I was Chief Integrity Officer over at the Division of Medicaid. And Medicaid has a program called the Third Party Liability Program. Medicaid is a payer of last resort. So when someone has a automobile recovery where there's a medical portion paid and Medicaid has paid, Medicaid can recoup what it has paid. And this will be the same sort of thing where a custodial parent recovers in a liability or automobile accident case, and they will run a check with our arrearage database. And part of that recovery will be applied to arrearages for children, for child support. Again, we're kind of hammering out some of the details, but we've been talking with the insurance industry and met with members of their policy council, I think it was last week. They asked us to consider a couple of amendments to our bill, and we'll do that. And I think again, they won't be a cheerleader for the bill, but I don't think they will stand in the way, or at least that's what my sense is at this stage. All right, I want to talk to you a minute about our newest program in child support, and that's our Fatherhood Initiative. We've been looking at putting a child support and a fatherhood initiative together. The whole idea behind the Fatherhood Initiative is to increase the financial stability for families by helping. One of the biggest problems for non-custodial parents is if they don't have jobs, they obviously can't pay child support. And part of the efforts we will be engaged in through our Fatherhood Initiative is helping those non-custodial parents find jobs, improve their wages, and meet their child support obligations. Now, who does this program apply to? Well, non-custodial parents who are about to face a contempt action or who are at risk of losing their driver's license for non-payment of child support, they're eligible to enroll in our Fatherhood Initiative. What do they get from us? They get our support in helping them get a job. They get the ability to have their driver's license, either keep it in good standing or get it reinstated. And they get the opportunity for us to look at their child support and sort of right size it. If they feel like the order that's in place is too burdensome based on what their current income is and hasn't been right sized, nobody's been back to the court to say, well, this order was set in place when his income was $70,000 a year. Now he's making $25,000 a year and he's at the same level of support. We need to right size some of those support orders. And we'll be looking at that. We're actually already engaged in this Fatherhood Initiative in Madison County, Washington, Lee, Harrison County, and a few adjacent counties. And we're in the process of beginning to expand it statewide. We had to, again, in a dialogue with Office of Child Support Services, our federal oversight agency, we've gotten their green light, so to speak, to begin to expand this program. We just started it in July, so we've only been at it for 3 or 4 months. We've had about 52 referrals so far. These are self-referrals. We don't mandate that anybody participate in the Fatherhood Initiative. We give them the opportunity. And so far we've had 52 of them, 40% of those have never made a child support payment. So this is a good thing for them to come and dialogue with us about how we can get them to the point where they can begin to make child support payments. Really have only had 4 what I would call fully successful enrollments. And I know that doesn't sound like a very big start, but this is a new program that we're just rolling out, and it's only been out in those 4 or 5 counties. 21 more folks are right in the middle of the enrollment process right now. We are partnering with the Department of Employment Security to refer our enrollees in our fatherhood initiative to the WIN job centers. And because we don't have staff dedicated right now to this fatherhood initiative, we will be hiring additional staff in order to expand the program out to more locations and across the whole state, and to deepen the services, to expand the services that we're offering. I'm pleased that we have gotten this thing off the ground, but I will be the first to admit we got a long way to go. We got a lot of work to do. We will be doing one of the assignments Mark has is we'll be doing a campaign basically to announce this program across the state and encourage non-custodial parents to get involved. And then one last program I want to mention to you, it actually kind of works hand in hand with the fatherhood initiative. And it's part of our child support program as well. And that's the Mississippi Access and Visitation Program. That is funded through a grant, a federal grant. And the whole idea is to get non-custodial parents connected with their children, to give them access to their children, to help them set up visitation. Some of them don't have visitation rights. And so this program is, designed to help them get visitation orders if necessary with their children so that they can become more regularly involved with and have a presence in those lives. I think if anything that's clear to all of us, it's the fact that 2 parents being involved in the life of a child can have a significant impact in that child's life and for the good. And what our access and visitation program does is it gives parenting education. A lot of our mothers who are in our child support program are young. They're teenagers, early 20-year-olds. They're not. And of course, let's be honest, none of us before we became parents were knowledgeable about what parenting really looked like. We could all benefit from parent education. I know my wife and I years ago had parenting education in our local church, and certainly I'm sure that many churches still offer that. But we are offering parenting education. We're offering non-therapeutic counseling, and by that I mean we're not counseling folks with mental health issues. We're offering them counseling about how to cooperate, collaborate, co-parent with each other. And we do provide some pro se paperwork to help with getting those visitation orders in place. And we work with developing co-parenting plans with custodial and non-custodial parents, and then some mediation services. A lot of times couples, parents who aren't living together, they need an arbitrator, they need a mediator, they need a third party to help them sort out what does this visitation need to look like, and how do we get to a place where everybody is satisfied with what the visitation and what the access to the child or children actually looks like. So that's what we're doing in regard to child support. Denise and I are happy to answer any questions you may have, Madam Chairman or members of the committee.
I've got a couple of questions. First of all, I would love for you to get us back some more information, really with the numbers and all of that on the pass-through goal. just like, especially to, if you can get us back more information about if we're gonna have to reimburse the feds for a little bit, like what that would cost us to do that versus, um,
Well, I can give you a number today. I will tell you,
Okay.
we've already looked at to go to a full pass-through, it would cost us over the next 10 years, am I right here, Denise? About $2.6 million. So, and you know, that works out to about $260,000 a year.
Okay.
It's not a huge amount. We just have to pay back the, you know, the federal share.
But that, do we have the numbers that would equate to for these Mississippi, for these families? Do we have, like, we would have to do that over 10 years, 2.6, but what's the money that would go back in the pockets of these Mississippians?
Yeah, give me just a minute. We have those numbers as well.
Yes, for example, just looking at the last federal fiscal year, 2023, had we had full pass-through, 1.9 million, over $1.9 million.
Just this last year?
Yeah,
Right.
just
Right.
federal fiscal year 2023.
And I think our estimate was it would stay around that 1.9, maybe a little more, $2 million a year, which again, through our pass through over the last 2 years, we've only been able to pass $600,000 back over those 2 years. And if we go to a full pass through, it'll essentially increase that number, you know, by almost fourfold. And I think is a good investment for the $260,000 federal share to generate $1.9 million in child support into the homes, into the hands of custodial parents to do what they know how to do best for their children, to buy them some new shoes, some new clothes for school, whatever.
Bob, is it realistic to say that this pass-through might help some people get off public assistance?
That's certainly a possibility. I mean, every dollar that we get into their household, particularly if, you know, it allows them to get enrolled in an education program or something, it could help bring them off the TANF rolls or off the, SNAP is a little different because the threshold's a little higher for SNAP, but it certainly could probably bring some folks off the TANF rolls.
Okay, then let me go back to the fatherhood initiative. I'm kind of 40% of these individuals in the fatherhood initiative have never made child support payments at all.
That's right.
Okay.
You want to speak to that?
You have that is correct. 40% of the referrals that we received into the program had never paid child support at all. And understand that the source of the referrals, some of them are self-referred, but some of them were cases that were already slated for a contempt action. And so it was diverted to us for that program to see if we could get them to pay child support after having employment services.
Okay. I'm really going to be interested to see some data like next year as y'all really get into the program. And I really would like to see like how many children, do you know what I'm saying? How long they haven't been paying, like if this is something that they just haven't paid for the last year, do you know what I'm saying? Or 2 years, or has this been a long-term trend? I think I'm very interested in seeing additional data from that. And y'all probably have some other data pieces you would like to see from this. Additionally too, I would love to see y'all also help them partner up with their community mental health center, because if these are people that are not working, I'm going to ask why. Is it health? Is it mental health? Like, do you know what I'm saying? Like, what is the reason these people aren't working?
Sure.
Yeah.
Well, and one of the things that as we expand this program, one of the deeper parts of that we're expecting to add is partnering with folks like community mental health and other mental health agencies in order to see if that's the explanation, like you're saying, and you know, to just increase the wraparound support for non-custodial parents. I mean, let's be honest, The focus in our child support program right now has been on custodial parents, as well it should be. They're the ones who are caring for the children. But we need to get behind, like you're saying, Senator Boyd, why is that non-custodial parent not supporting or not able to support, not physically, mentally, emotionally able to support, his or her children? And what can we do to help get them to a place where they can be supporting their children?
Many of them also do receive and take part in the federal program that helps with employment as well. So that's why I'm very curious
Right.
about this. Let me ask you, and the Mississippi Access and Visitation Program, and I know that federal grant on that, are these individuals that are that this will be open to on this fatherhood initiative to get custody, are they paying child support at this point in time right now? Or is that a criteria of the program?
No, the Mississippi Access and Visitation Program is not premised upon whether or not the non-custodial parent is paying child support. It is designed to provide access. It was designed to provide therapeutic counseling and mediation, but it's not designed for enforcement. It's designed to encourage access. That's part of the contours of the grant.
Okay,
But now, our hope is, and our plan is to braid the fatherhood initiative with the access and visitation program and make those work together.
okay. Because I see there's a lot of problems if they're not making any good faith effort to contribute to child support. I could see a lot of issues with that. So,
Well, and honestly, what we have seen with, those who participate in the access and visitation program, just having access to their children, seeing their children, has led to an increase in their child support payment. So that's the whole idea.
okay. Do y'all have additional questions? All right.
Director Anderson, I wanted to go back to your return on investment cost effectiveness, because I too periodically, in fact, probably more than periodically, get comments made to me about the vendor.
Yes, sir.
And looking, assuming your numbers are right, which I have no reason not to think, you collected $357,168,068. Or y'all did. What is the cost of the contract with Young Williams?
The cost of the program.
Cost of the program, the cost for the vendor is about 25 million a year, I believe.
25 million?
25 million.
So when people are saying, like you alluded to it, you hear that, what are they getting at?
Well, I think some folks have the idea, and that's certainly, they're entitled to their own views, that the state should not be giving this program to a private vendor. It's just simply an objection to the notion of privatizing the child support collection program.
Throughout Mississippi government, we do contracts
Absolutely.
in every agency, so.
Right. Well, look at Medicaid. We have 3 managed care plans that we pay $1 billion a piece. So, that's, that's privatized, and nobody complains because it delivers the care, or at least it tries to deliver the care to Medicaid enrollees.
I'm sorry, go, apologize. If y'all brought it in-house, well, what it sounds to me like is, let me back up. If you brought it in-house, the cost effectiveness would not be as good for various reasons.
We have run those numbers a couple of times recently, and yeah, we don't think we could replicate. And this contract is up for renewal in 2026, I believe. We'll probably run a RFP next year. One of the things we did 3 years ago when the current contract was bid, we solicited for 2 vendors. We wanted to have 2 vendors to just compare, performance, because people say, well, if you've got a captive one vendor, then, you know, you don't get the full benefit of competition that would deliver better services. That may or may not be true, but we can't have competition if we only have one vendor. We solicited for two vendors, one for the northern half of the state, one for the southern. Unfortunately, we only got one responsive bidder. We had another bidder, but when we looked at their resources, they really couldn't practically manage the program. There are some other companies besides Young Williams that are in the child support business. And when we bid this out again, we hope they will submit a proposal. And we'd like to have a northern half, southern half, and be able to maybe even be more cost effective if we have two vendors who are competing with each other.
What, and so under the current contract, the attorneys who handle this in the court system, they're DHS employees?
No, sir, they're Young Williams child support attorneys.
Okay.
We have a handful of attorneys in the state office who handle financial institution, financial in,
The
Finan-
financial institution garnishments and the bankruptcy, as well as the settlements from personal injury.
right. But all the rest of the establishment of paternity, the establishment of paternity orders, the collections, the contempt orders, all that's done through child support attorneys who are employed by Young Williams. They have, how many 24 regional offices? Is
I
that
think
right?
that's correct, yes.
And, you know, scattered out across the state. And they have a statewide call center that, you know, manages the call volume for the program.
Could we, at the next contract, look at maybe building in more attorneys that they're required to provide?
Well, they're up, the number of offices they have now is up from the last contract. We asked them to open about a half dozen new offices, I believe. We'll look at that, definitely.
Okay, thank you.
Yes, sir.
Senator Blackwell?
Thank you, Madam Chairman. Bob, you had mentioned had some pass-through bills you tried to get through last year. Do you recall where they died, if they got through committee or?
Our bills.
Yes.
The gaming bill cleared this chamber. It got hung up on the other end of the building in committee. The insurance match bill, I think it was headed for success in this chamber. It may have passed. Did it pass out of this chamber? It died in committee. Well, we got a request from the industry. We had given them the bill well in advance of the session, but they told us in February, early February, I think it was, they hadn't really had an opportunity to study it. And they asked us if we would pull it back. And we essentially, I think, talked to both of our committee chairs and said, just sideline this bill for this year. We'll be back next year. And so that's where we were with the insurance match bill. Yes, sir. Thank you so much for the opportunity to speak to you again.
Gentlemen, how are our technical difficulties? Okay. I'm good, thank you. All right. Thank you so much for hanging on. Elise, can you hear us? Okay. Jeremy, thank you for hanging in with us too.
Yeah, you're welcome. I don't see Elise listed as a participant, by the way. Somebody may want to text her and let her know she can sign back on, maybe.
Okay, they're getting her right now. So.
Okay. All right, going back on mute.
Can you hear us? I think you.
I can
okay.
hear you.
Wonderful. We can hear you now.
Oh
So.
my gosh. Well,
So,
that was dramatic. That was a very dramatic start.
we're glad you were with us and you have helped us on a number of issues throughout the years. So we are very glad to have you talking to us today. Thank you.
No, thank you, Chair Boyd, and members of the Senate Study Group on Women, Children, and Families. It's a new group, right? So that's really awesome. I'm Ilsa Connect, and I'm the Policy and Advocacy Director for the Joyful Heart Foundation, and I manage our End the Backlog campaign. I've been at Joyful Heart for about 10 years. And before that, I was at the National Center for Victims of Crime for almost 20 years in DC. So Joyful Heart is, we're thankful for this opportunity to testify today about rape kit reform in Mississippi. I first want to send a heartfelt thank to Lieutenant Governor Hostman, Chair Boyd, and members of this, excuse me, important committee for first establishing the committee and for holding this hearing. And thank you to Senator Boyd for your commitment to ensuring that survivors are seen, heard, and supported in Mississippi. That really does mean a lot. So thank you. We're also grateful for our partners over the last 2 years, including the Center for Violence Prevention, who helped bring about mandatory rape kit testing in Mississippi a couple years ago, 2 years ago, I believe. The Joyful Heart Foundation was founded in 2004 by Law and Order Special Victims Unit actress and advocate Mariska Hargitay to transform society's response to domestic violence, sexual assault, and child abuse and support survivors' healing. When she started in that role, Mariska trained at a rape crisis center and became so, inundated with the material. She also got letters from survivors saying, I've never told anybody this, or, this is something that I feel like I can share with you. And that created this feeling inside her, this urgent need to do something about sexual assault in the United States. And so she created the Joyful Heart Foundation. Since 2010, Joyful Heart Foundation has made eliminating the nation's rape kit backlog our top advocacy priority. And we have been working over those years with survivors, stakeholders, and elected officials and other agency leaders to achieve that goal. We've been instrumental in passing state level reform legislation in 48 states, including Mississippi, Alabama, Florida, Georgia, Kentucky, Louisiana, Missouri, and Tennessee, and all other parts of the country that we probably don't need to mention today. We've collaborated with local and state agencies to provide support also during the implementation process of those laws. We don't like to pass the law and then leave and hope it works. We're very into making sure that laws are being complied with. I want to say before I kind of get into the meat that we support all of our partner RAIN's proposals here today, and we are here for whatever we can do to support any of those legislative measures moving forward. In 2023, the FBI received 939 reports of sexual assault in Mississippi. I want to say really quickly, there are a lot of questions about the numbers in Mississippi. I'm not going to get into that today, but in terms of the reporting numbers, they're kind of all over the place from year to year. And so that's another topic at some point I would love to speak to you about. For those who don't know, in the immediate aftermath of a sexual assault, a victim may choose to go to a hospital or medical facility to get DNA collected that might have been left behind by the offender. A doctor or nurse will collect and preserve this evidence in what is commonly called a rape kit. So DNA evidence, we all may know more now than before because we've seen it in the news, we've watched TV. We hear true crime stories, though, is a powerful law enforcement tool. When tested, rape kit evidence can link crimes together, can reveal serial offenders, and also exonerate the wrongfully convicted. Unequivocally, testing rape kits solves crimes and saves lives. Research has shown that serial rapists are often repeat offenders, or that rapists are often repeat offenders. They assault both acquaintances and strangers, and they often commit all kinds of crime, from burglary to domestic violence, to child abuse, to homicide. They're not specialists, and they actually don't stop until someone stops them. Too often, however, the evidence contained in the rape kits languish untested for years, even decades, in storage facilities. So 10 years ago, when we started this campaign, there were approximately 300,000 to 400,000 untested rape kits nationwide. That's an unbelievable number, and sometimes I read it still and it makes my head explode. Like, how is this even happening? But what's really makes it even sort of harder to comprehend is that behind each one of those kits is a survivor waiting for justice and a perpetrator left on the streets to keep inflicting harm over and over again. And again, research has shown that many rapists are serial offenders, and while they are often a gigantic burden on law enforcement and traveling across the country, victimizing people in various communities, the evidence that could stop them is sitting on a shelf, gathering dust. So that's the truth that drives our work at Joyful Heart Foundation. Our campaign is focused on urging states to pass 6 pillars of rape kit reform to successfully address the rape kit backlog. And these pillars, when we came up with them, were vetted with more than 75 experts and survivors across the field. So we came up with this kind of schematic to help people who said, how do we know that, we're addressing this and we're actually ending it forever? And those 6 pillars are conducting a comprehensive inventory of all untested kits to understand the scope of the problem, eliminating the existing backlog that is uncovered in that inventory by testing all of those kits connected to a reported crime where a victim has consented to the testing, preventing future backlogs by mandating testing of new kits, which Mississippi has, establishing a tracking system which follows a rape kit from point A to point Z, so from the hospital all the way through law enforcement storage to the crime lab and destruction. Granting victims the right to know the status and location of their kit. Again, Mississippi has this. So yeah, you have 2 of our pillars. And allocating state funding dedicated to testing rape kits and just maintaining all of these pillars. Very important to fully fund your crime labs, make sure that they have what they need, that they're using the latest technology, and that they're really operating efficiently. So rape kit reform in Mississippi right now, where it stands, you've made some very positive steps forward, but there's some work to do. We were lucky and very thankful to be involved 2023, last year, when Mississippi enacted a rape kit reform bill for the first time, and that was after many years of trying. HB 485 established rape kit handling timelines and granted victims the right to know the status and location of their rape kit. So under that law, hospitals are now required to notify police within 4 hours of when a kit is collected. Law enforcement has to pick up the kit within 24 hours of that notification and submit it to a crime lab within 7 days. And then the crime lab has 45 days to test the kit. The law also required the state to study the feasibility of implementing a statewide rape kit tracking system. So the next steps for Mississippi are to conduct an inventory of untested rape kits that are on the shelf and to legislatively mandate the rape kit tracking system that is developed at this point. And both practices I want to mention, actually, all of our 6 pillars are practices that are widely accepted across the country and by the United States Department of Justice. So it's something that the pillars are, like I said, they're widely accepted. And in the 2017 report by USDOJ, they said these are the best practices for handling rape kits. So right now, we don't know how many rape kits are languishing unanalyzed across the state of Mississippi because Mississippi has not conducted a thorough inventory of untested kits that are sitting in hospital and law enforcement custody. And so just to be clear, this is about kits that never made it to the crime lab. They've been sitting in other places, potentially for decades. And in some places, they don't even actually know what they have sitting in their storage facilities. One really strong thing I want to mention, I just spoke to somebody today, actually a SANE nurse in Mississippi, and she said that since HB 485, folks in the field are saying that it seems that law enforcement is sending more and more of their older kits into the crime lab. So it was even sort of a message too that this is the right thing to do in testing kits. So I'm hopeful that when an inventory is done, that there aren't that many kits still remaining on shelves, but of course, 1 is too many. So Joyful Heart strongly recommends that the inventory be set in law and that agencies are required to participate because we've seen in some places when it's not in law, the compliance rate goes way down. Agencies just don't send their numbers in. A time frame for completing an inventory like this would be about a year, but some places have done it within 6 months. Especially if you don't have that many of them. In places where we've found 15,000, like North Carolina, that took a little bit of time, but they're still pretty able to manage most of it within a year timeframe. We suggest that one entity oversee this process. It might be the state lab or the Attorney General's office. And then that a full report is made accessible online for the public and for transparency's sake once that is done. So as of November 2024, 45 states plus Washington, D.C. have conducted an inventory, including Alabama, Arkansas, Florida, Georgia, Kentucky, Louisiana, Tennessee, and Virginia. So only a few states have left to count their kits, and Mississippi is one of them. Once the inventory is completed, the legislature can then make plans to test these kits and appropriate resources to eliminate that backlog. So again, just reminding that kits sitting on shelves means dangerous people are on the streets. And too many communities across the country have learned what this means. Unfortunately, they've learned of tragedies that could have been prevented if a rape kit had just been tested. I can provide those in written form for you, if that would be helpful. So our second recommendation is to ensure that the state's rape kit tracking system is also established in law to ensure participation by all agencies that handle rape kits. That kind of tracking system provides visibility over the state, where the rape kits are, where are they being collected, are they being picked up by law enforcement? Are they being sent to the lab in the time frame that they are supposed to be done under HB 485? And are there any kits that are sitting where they shouldn't be? So newly collected kits, like I said, are required to be submitted to the crime lab within 7 days. And there's not a really good way to know if that law is working unless you have a rape kit tracking system. Tracking rape kits is crucial to holding hospitals, law enforcement, and crime labs accountable. It ensures that all of the entities that are handling rape kits are following the laws dictating the processing timelines under HB 485. And importantly, tracking systems should also include a secure victim access portal through which survivors can obtain information about their kit and receive critical updates about it. So tragically, most survivors leave the hospital and are never contacted again about their rape kit. And generally their attempts to find this out are ignored. And if you can imagine if you had something so important as that done and then never knowing where it was again, it's like if you went in for a test, for cancer. And then just nobody ever called you back to let you know what happened. And, they never answered your calls. Sexual assault survivors want and deserve information about the status of their kits and their cases. And in 2016, Joyful Heart Foundation conducted research on victim notification. And what survivors told us was that access to information about the status of their cases and their kits can promote healing for them. But the lack of it also is very detrimental to their well-being. So these systems empower victims, allow them to heal and seek justice, and really counteract that loss of self-determination that survivors experience from the sexual assault experience. So it appears that the tracking system is currently being used by the Missouri Department of Public Safety, has that option, has the survivor portal, and we applaud that. To date, 34 states have rape kit tracking systems in statute. 10 states have established it without law. But once again, I'm going to say this needs to be mandated in law. I'm going to give you an example why that not doing that is not a best practice. Arizona established its tracking system in 2019 statewide. But because there's no law requiring participation by rape kit handling entities, to date, Phoenix, the largest city and jurisdiction with the most sexual assaults in the state, has chosen not to participate in the system. Phoenix now has a backlog of around 500 kits. They had about 800, but then they were forced to outsource them to a private laboratory. So there's no transparency around what is happening with the kits in Phoenix. News outlets have issued open records requests to get their untested kit count. But the very sad part of the story, of course, is that survivors in Phoenix have no access to information about their kit. And being able to know where your rape kit is in Arizona is dependent on your zip code. So that seems very unfair. So HB 485 required a report on the feasibility of a system by TPS and the Sexual Assault Evidence Accountability Task Force, but it did not mandate participation. So let's make sure that the Phoenix fiasco does not happen in Mississippi and mandate participation in the tracking system by law. In addition, cementing the system in law protects it from political winds of change. Let's face it, some priorities change within administrations, and some folks in power care more about sexual assault survivors than others. So again, putting it in law makes it something that will withstand change. So the road ahead for Mississippi, again, you've taken some meaningful steps towards rape kit reform, and we applaud that. And I've been very grateful to be able to be supportive and helpful in that endeavor. But by enacting legislation requiring a comprehensive rape kit inventory, untested rape kit inventory, and mandating the development of a rape kit tracking system, Mississippi will be well on its way to full rape kit reform. I want to mention one more issue that just came up today when I was talking to somebody is about survivor access to sexual assault nurse examiners. Apparently, there are certified SANEs in Mississippi, but not that many, which is not uncommon. That's kind of the situation across the country. It's widely recognized that having a SANE is a best practice for survivors, but what is happening is that some hospitals now are apparently turning away survivors because they don't have a certified SANE. Regular medical professionals can administer a rape kit, but it's better if they have some training. So I think a conversation needs to happen around some sort of legislative response about this problem. And we'd be glad to, be involved with that. So lastly, while I'm here primarily to talk about rape kit reform, Joyful Heart is also now focusing our energy on image-based abuse or the non-consensual disclosure of intimate images. So Mississippi did enact Walker's Law, which was great. It was covering the devastating crime of sextortion. And Mississippi law does prohibit the disclosure of intimate images without consent of the person that's depicted, but it appears not to include synthetic images or images that are digitally manipulated. So that and a couple other things, including the intent element in the statute, is very specific. And so we would love to work with you to have a conversation about this and update that and related statutes. So I just want to end by saying that we've really enjoyed working with the great legislators and advocates in Mississippi, and our great friend Donna. I know she's out there somewhere. And we look forward to working together to advance more policies that protect public safety and support survivors. So I want to end by just saying, let's send a strong message to dangerous offenders that we will use every tool in our toolbox to identify you and to stop you from harming others. And to survivors, what happened to you matters, and your case matters, and we will do everything we can to help bring a path to healing and justice. So special thanks to Senator Boyd for asking me to present today, and we are looking forward to much more work together. So thank you so much.
Thank y'all. Do y'all have any questions? Senator Blackwell?
Thank you, Madam Chairman. It's really disappointing and appalling that these rape kits are not being tested. Is there anything that stands out as to why they're not sent? Because I just, being in healthcare myself, I just have a hard time seeing the healthcare professionals just go through the trouble of collecting that and then throwing it on the shelf. And so I didn't know if there was a cause, or maybe the victim has decided not to pursue things and that's why it's sitting there. But could you help me with that?
Sure. That does happen. I will just start by saying there are times when a survivor may have evidence collected at the hospital and decide at that point they don't necessarily want to move forward in the criminal justice process, or they don't want to talk to law enforcement. And so those kits can be held for a certain amount of time. I'm not remembering in Mississippi what it is. I think there was some change to that recently, in recent years. So that does happen. But generally the kits that are connected with a survivor who has reported the crime, has wanted the kit to be tested, it comes down to a couple of things. And one has kind of generally been that the crime of sexual violence is not a priority for the criminal justice system. And that kind of comes out in different ways. There's also victim blaming, victim bias still kind of present in a lot of communities and law enforcement to this day, where survivors are not believed. If there's any kind of credibility issue with survivors, sometimes their kids won't be sent forward. It's hard to say, but a sex worker or somebody who's kind of known to the department, they might have drug abuse in their past. Those types of survivors, unfortunately, are often the ones that are neglected, and their cases are not taken seriously. And then generally just a lack of knowledge about DNA, about how DNA works, how the DNA database works. I still hear sometimes, we don't send kids in when there's not a known offender, but that's why the database exists, right? Because one part of it is people who have committed crimes in the past, and their DNA profiles are there to match to the crime scene evidence. So it's, sometimes a lack of training, a lack of knowledge. But, you know, even funding is a problem. When you have some limited funding, you know, what cases are you going to pick? It seems like what we've seen in the past is that law enforcement will pick the cases that seem most credible, or most likely that the prosecutor will take the case. And in the end, sometimes it's a lack of trained investigators who know how to really take these cases and investigate them. So it all comes down to kind of a failure of the whole system to take these crimes seriously, put the resources where they need to be, put the training in, and really investing in making sure that these cases are thoroughly investigated and, you know, that offenders are brought to accountability.
Thank you.
I talked for about 4 hours about that.
If we were to mandate a cleanup of our, all these test kits, do you have any idea of the time and the cost that the crime lab would encounter?
Well, most of the states that have identified large numbers of untested kits have been outsourcing those kits to a private laboratory, or there are a couple private laboratories in the country. Those labs will test the kits sometimes. They used to be $500, but I'm sure, you know, with inflation and everything, it's more now. But sometimes basically sending out a batch to a private laboratory that can do them a little faster is really the best route. But, you know, we're talking about somewhere between $500 to $1,200 a kit for kind of the easiest cases. Sometimes when they're more complicated cases, multiple offenders or, you know, something like that, the testing can get a little bit more expensive. So it just depends a lot on how many kits are found and then how the lab wants to handle testing those kits. If they keep them in-house, it'll take much longer for sure, and probably cost more money.
Thank you. And will you get us the additional information that we need to add on the digital images under Walker's
Yes.
Law too? If you will help us do that as well. And that would be a great
Yeah.
help in that too. So,
Okay.
and we will continue to work with Donna. I think we've got some language on looking at some of these issues as well. So thank you
Yeah,
very much. And we appreciate you hanging with us in our technical difficulties today.
It's fine. Thank you
Thank
so
you.
much. Appreciate it. Thank you.
Bye-bye.
Bye.
Okay, Kelly, I'm sorry. We switched around. We had some technical difficulties, so I apologize and I appreciate you hanging in with us. Y'all, this is Kelly Hardwick. For those of y'all who don't know Kelly, he is the Executive Director of the Mississippi State Personnel Board and a former law school classmate. So we are glad to have you. Thank you, Kelly. And you're going to be talking with us today about paid maternity, paternal leave, and also to Kelly, will you also tell the committee to own how that the revamping of the when we did the ST squared that we brought wages up too. I think that's really interesting information for the committee.
Absolutely. Thank you, Madam Chairman, for allowing me to come to tell you a little bit more about, if you're not familiar with the State Personnel Board and what we do. We're the HR management agency for state government. And under the legislature, we're charged with administering the state personnel system for state employees. And in other words, we're here to equip your agencies with tools to achieve their mission. Statutorily, some of the things that we're responsible for is the competitive recruitment and hiring and promoting of employees based on their knowledge, skills, but not their political connections, which is in essence a merit system. Also to help provide equitable and adequate compensation in all forms to employees, and to ensure the fair treatment of applicants and employees without regard to their political affiliation, race, national origin, sex, religious creed, age, or disability. And so I'm here today to talk to you as much about data and data-driven decisions on whether paternal and maternal leave would be beneficial to state employees, and is it something that's necessary and something that you should consider. I take the old soggy sweat. We're neither for it nor against it on this sort of leave from a state employee standpoint. Our job is to, as a part of the executive branch, is that if the legislature says to do it, we're going to do it, and in turn of that. But what would remind you is that by law, we don't look to single out any group, whether it be just mothers, just fathers, or just parents of new children. And what we're looking to from the benefits is to make sure that they're equitable and don't show any benefit to just one group. And from our stance, especially from the leave standpoint, part of our philosophy is the challenges of parenthood go far beyond 6 to 12 weeks after the birth of a child. And so we're looking for our policies to make sure that they work from a larger perspective for state employees. Now, so let's talk about, you've been given a short and brief data-driven information. So let's talk about the state leave policy as it stands today. All full-time employees begin accruing paid leave from the first day of employment. And it is, a couple of attorneys here, they will get it, but it's a property right from day one. And so what that means is that once you start working as a state employee, you accrue this leave. And as you can see, for a new employee, the personal leave, you start accruing 18 days a year, and major medical 12 days a year, for a total paid of 30 days that you accrue from day one, which in a year's time. So from our standpoint, if it's been talked about, 6 weeks paid or 12 weeks paid, but from our standpoint on the leave, a new employee from day one will have accrued in 1 year's time 6 weeks of paid leave if they were to have a child. Male or female, they can accrue that if they want to. If they don't take any time off, if their only time off is they work 40 hours a week and they're taking the weekends and the holidays, we get 10 holidays, things like that. You say, I'm going to decide, they can accrue that from the get-go in 1 year. So if you did 12 weeks, they could do it in 2 years if they decided not to do it. And so from medical leave, the FMLA covers the 12-week unpaid. There's also the Pregnancy Workers Fairness Act, which came down in 2023, which is a federal law that it provides enhanced protections related to pregnancy, childbirth, and related medical conditions that you have to deal with from following a federal law. And we're working on our policies to kind of see how that sets out. As you know, when the federal government gives you a mandate and sets something out, it takes them a while to figure out what they did and what their expectations are. So we're working from that, and we've got those under the guideline. And so from our standpoint, our policy says this, is that all types of leave will be granted to pregnant women on the same terms as leave granted to any other employee. But that, from our standpoint, when they first start, they have that opportunity, they could accrue that leave. And so you said, well, Kelly, why is that important from an overall standpoint? Well, that's to some degree outside the norm of what you would find in the private sector. Generally in the private sector, you don't accrue it on day one, and it's different. But for state employees, and this includes what we're going to talk about, this will include the teachers that would be part of this, that fall under our state health insurance plan. And why does that matter? Is that they have, it is a benefit that is unlike what generally happens in the general populace. And so, in talking about, what would it cost to do this? And from our standpoint, now these are real costs, because one of the misconceptions is well, if we're if we're paying from them, we would be paying them anyway if they weren't doing it, if they were just using their leave. But the way our leave, because it accrues and it is unlimited and it continues to accrue during your time, if you're not using it in that paid leave in that time, so say the state pays you, you continue to accrue the leave and you get to carry it forward. And that's important because of the way our system is set up, unlike a lot of other states around us, is that it's unlimited. So here's the example that I tell you is why we say, you give it to, I'm just going to, for easy sake, maternity 6 weeks, we're going to pay. That was the bill, that's what you give us. So what happens is a person goes and, okay, I'm getting paid for that, means I don't use that leave. Well, they get to continue to keep that leave when they retire. So here's the example. They work 10 years, they have 2 children. They use 6 weeks both times. So when they retire, they would not have used that 480 hours of leave over that 10-year period. And so when they left state government, they would get a check for 240 hours, 6 weeks that they accrue. So they could get a 240, they didn't use it, so they accrued. So you paid it. So not only did you pay that time, you paid it when they left, but also those extra hours get turned into serviceable credit with PERS. And so the biggest admonition I would give you, it's more important for you to talk to PERS about what the impact is on this as much as it is from the appropriation side of it. Because under that scenario, they would get another, say they would have 10 years. They get paid 240, but they have credible service. So so instead of retiring at 20% of what they made, they would retire once they were able to pull it, at 20 and a half or 21% of what they would make. Now that's not a big difference, Kelly. But if you're talking about a couple thousand a month with a couple of thousand people over the lifetime of PERS, it's something that they would have to calculate. And how does that affect? And that's unusual the way we're set up from our state government employees. And so I don't want to stand up here like I'm saying you don't do it, don't do it, don't do it. But I just wanted you to hear from a data standpoint where we are and to go in it with eyes wide open. And from a state employee standpoint, it's bigger than just how much is it going to cost. So we've given you some calculations there. And because of our workforce, 62% of our workforce is female. And of that, 56% falls within I think it's some worldwide group that says between 15 and 49 are childbearing years. I'm not going to quit, but we needed a number to give you to be able to come on this to be able to do it. And so for employees, the average cost for 6 weeks is $6,500. There were 1,927 births under the state insurance plan, which would be teachers and would be state government employees. And that equates to $12.6 million a year. And again, it's a circumstance that if they're not working and you're paying it, if they use their paid leave, they're getting compensated that way. But if they're not using that paid leave that they accrue, you're going to pay for it at some point, more than likely. And so that's from our calculation of what you can consider, and from a budgetary standpoint of what it would cost the state to do that from that standpoint on the cost of just outside of people not working, they're going to be paid a certain amount. And so I also wanted to talk a little bit about what other states are doing around us and give some and quantify some of that. As you could see, Louisiana and Georgia, it's a paternal leave, and it's 6 weeks. Tennessee, paternal excluding 6 weeks. Texas, and you can see their listing of what other states are doing. We are in this group. We're a little bit more similar to what Alabama does with their state employees than the others, is because some of the other states, like I said, their accrued leave is unlimited. Arkansas, with the 12 weeks, has set up what's called a catastrophic donated leave policy where people can pay into it. So I could say, hey, what I want to do, take 10 hours of my leave and put it in this to be able to help them. Well, it has to some degree a wash with the state, is that That's 10 hours I can't roll over when I retire, or 10 hours I can't get paid for. And so it's amongst state employees. And so that's one of the ways that they're helping to pay for that. So they had a one-time payment of putting it in there and setting it out. So that's how that works. And a lot of the onus is on other state employees and other people to pay into the fund, to people to pull out. We have something similar, but we don't have this specifically set out. Pregnancy is not a catastrophic event in Mississippi. But it is now according to in Arkansas how they defined it. So it just becomes on how you define things. Other states, they limit where they are, and other states have just decided, hey, we're going to spend the money. Tennessee is flush with money. That's the matter of fact of it. And so other states do other things, but there is a caveat for every one of those to do it. So I would caution you just to say, hey, North Carolina does this, and so we should do it, because North Carolina is different the way we operate and how our state employees are treated from a leave and a benefit standpoint. A decision was made, I think, years and years ago, is that our leave policies are more generous because of where we were from a monetary standpoint on how we paid state employees. And so, and we fell way behind other states, and we had fallen far behind the private sector. We were having a hard time doing it, which is one of the impetuses on when we did Project SEC Squared. If you're not familiar with that, is that a couple of years ago, we changed the classification and compensation structure for state employees and made sure that state employees, they were doing what they said they were doing and giving them career paths and helping get them into a position where we were competitive with our outlying states. Our philosophy is we're not going to be competitive with the private sector from a money standpoint. That's just our philosophy now, that we're not going to do it. I don't want to compete with Nissan. I don't want to compete with Ingalls. I don't want to compete with Toyota in pay, because that industry is important to us, and they don't offer the benefits that we have from a state employee standpoint. And so over the last couple of years, because of the good graciousness of the legislature who saw that we needed to come up, state employee pay has gone up tremendously. And enough to where we are competitive, and we believe we've stabilized to the point to where now we can reassess and determine, all right, do we need this? We've got this number of people. Do we need this number of people because we're going to pay them well? Fewer people paying them better is to some degree the philosophy there. And so there are approximately 8,000 women in state government out of 14,000. The average salary and for women under the age of 49 is $45,185, which is up tremendously over the last couple of years. And right now, one of the things that, from a state government standpoint, because we do work under a merit system, we are under a classification system. We are looking at it equitably. For state government employees, women's earnings, as compared to men, is much better than the national average and much better than the state average. Part of that is that we set that out. Now, there's always going to be a gap because of the realities of that men tend to be in jobs that are more dangerous than women. And those jobs that are more dangerous, and when I'm talking about dangerous, it's law enforcement, it's dealing with construction crews and dealing with more dangerous jobs, like things of that nature. Men tend to do those. Those are generally paid better. The reality is men die on the job more often than women do. And so there's always going to be that gap. But we believe, because we are at 86%, over 86% now, we have pushed that gap as about as close as you can get. And there are job classifications where women actually make more than men in the state government in Mississippi when you pull that over. So we think we're right at 100 with a percent of men and women making the same thing. So we don't differentiate. So we're better. It has gotten better as nationally. It's about 80% of that of men and women. Now there's some big discrepancies when you take the Census Department numbers they're in the 70s. And as you know, the Census Department, people report that. BLS, the Bureau of Labor Statistics, Mississippi is as a whole is right at 84%. Nationally, it's 83%. But again, for state government, we're above 86% of that percentage of where we are. So the legislature, I'm here to tell you, the legislature has done a very good job, we believe, in making state government jobs very competitive for anyone who wants to be a parent and anyone who has a child and who wants to have a child. You've given them the opportunities. They can accrue the leave and use that paid leave if they're responsible for it. I've had more than one on my staff that was able to do this. They work for me and work for us, and this is the State Personnel Board, and they were able to accrue 12 weeks leave. They took 12 weeks of paid leave because they planned to do it and was able to be paid. Their sacrifice is that came off of their leave balance, but they were still able to accrue enough where they took vacations. In particular, I'm thinking about, I know they took vacations and they took time off. And so I think from a state government employee that the legislature has done a very good job in helping us. It's a super big recruiting tool for us. There are tweaks. There's always tweaks to make it better if you wanted to. One of the big things that has helped is we have telework policies now that give parents the ability to, if they need to work from home, to take care of a sick child, things of that nature. So there are things that if the employee is responsible and the agency is responsible, we think the legislature has done a very good job in handling these situations. And so I'll be happy to answer any questions that you may have related to that. But that kind of finishes up the data that I wanted to give you some numbers of what we do for leave and what we believe would be the cost. And I would say this, that to wrap it up all together, is that as you move closer to deciding whether you want to do it, there are a good number of pitfalls that you would need to think about. There are equal protection clause that are issues that would have to be worked with. What is a qualifying event? The cost of it. PERS, let me repeat that, get PERS involved to be able to run some numbers, because what you don't want to be blindsided is have it out there and somebody asks that question and PERS goes, no, it's going to cost $50 million to do it because we don't do the calculations. I don't know the intricacies of how that worked, but I think it's something you would talk about doing that. And then there's recourse if the person uses it and then all of a sudden they decide to leave. Hey, I'm going to take my 6 weeks. I'm going to get paid for 6 weeks. Don't have any more time, and then I'm gone. And so there's a lot of things out there that we would suggest that if the committee does come up with recommendations, that we could have continued discussions about areas that we see as potential pitfalls that may fall into this, because so much of it is new. This is the last couple of years, really post-COVID, before this ever really started, in the last couple of years, to the rush to do that. And I think it's personally, as Madam Chairman noted, we were in law school together. She hung out with the Guff Abbotts and the Debbie Bell, the smart people. I had to hang out with the George Cochrans of the world. They didn't let me in on the smart kid side of it. But I do remember there's litigation coming related specifically to this. And I'd reminded the lawyers here, remember the Hogan MUW case, that a seminal case that Mississippi, Will Colon, Mississippi lawyer, old law partner of mine, that had preferred, you got to be careful about giving preferences to one individual group on anything you do. So that's the old lawyer in me, is to be careful and carefully think out these things of where we are. And I believe the best course of action is kind of keep going where we're going. You've done a great job and continue. The legislature has been attentive to the needs of state employees, and if to go further is to do some study.
Kelly, you mentioned something to me on the phone the other day, that our leave policies are a lot more generous sometimes than some of our our neighboring states.
Yes.
Do you have like what some of those leave policies are in some of those states? I was actually surprised that we got 12 hours. I thought we only got like
Yeah,
an hour in the state 100 years ago, we got 8.
Yes,
So-
so here's an example, and we'll use Arkansas as the example. They start out, theirs works like this way, is it gradiates up the longer you've been there. So for us, X number of years, you get more, X number of years, you get more. Personal, they're 12, 15, 18, 21, and 22.5, but you're capped on how much you can use and have. They get 12 sick every year, but it's also capped. And then you get a max on both of those of 30, so you can't get more than 30 medical. So they have several caps. And also they unused leave goes into the catastrophic leave bank that I was telling you about. So it's not rolled into their other stuff. Ours, on the other hand, is 18, 21, 27, and 24 and 27 unlimited. Now with medical, we start with 12, but we reduce down to 10.5, 9, and 7.5. But the difference is when you start out with 30, you would end with 35 combined hours, but it is unlimited. And you get paid for the 240, and all other hours go towards your credible service in your retirement, which is different. Most other states are capped. Like Virginia, there's no carryover for medical. You get a certain number of medical every year, and there's no carryover. Georgia is the leave balance more than 2030 can convert. You can convert it over excess, but it is capped on what you can use. And so that's one of the big deals, is that they cap the way you do it. The way ours is, and I don't know the philosophy. I wasn't around when this happened in the 80s, that when they first did this, but part of my understanding is part of it was the state's way of, hey, we know we can't pay you this much money, so we're going to set this up to be able to do it where you get the benefit to, hey, we're going to try to get you to stay 25 years. And we love long-term employees and want to do that. And it is one of the reasons, because we consider benefits part of the compensation package, is why we stay below averages for the private sector. And we look, and we want to be competitive with other states, but we don't pay near as much as the other states for state employees. Tennessee isn't there. Tennessee's lot higher than us. Arkansas, we were within about 5 percentage points of theirs on their average state employee. So yes, and that's one of the reasons why is that we consider that a benefit for those that from a vesting standpoint, we consider it a benefit, and we put it in our calculations on when we're doing our compensation calculations on what we recommend state employees are making.
Did the teachers have the same policies, or do they have different policies as far as leave is?
The leave is the same, but how they operate that is different than us. That's usually, I think that's done by school district. Each school district gets to decide how they implement what they want to do and how they do it. And so that's more of a Department of Education. But for state employees, we set those policies. And like I said, we're working through the Pregnancy Workers Act and doing some of that stuff. We're going to adjust our policies coming in the spring to make sure all state agencies are doing it the exact same way. But from theirs, it's different about how they want to do it. The numbers are the same. And that's why we went ahead and used them here, because for the cost standpoint. And that 12.6 million, the average state employee makes less than the average teacher from down the line. So that 12.6 is the minimum.
Okay.
And so it could be more, but they do that individually. And I think the local school districts, they may have some Department of Education guidance, but I think the local school districts kind of set that up, especially because now, some of them are going year round, some of them are doing different things. So they implement that in a different way.
Okay. All right. I think we may have do y'all have any additional questions on this? Senator Hickman?
Good Good morning. Just a couple of questions, and I will say, I kind of agree with your premise all the way around in that, of course, well, not of course, but I support some type of a leave, but my main concern is how do we pay for this? How do we make this equitable and all those kind of things? So I had just a couple of questions for you. One, and I was trying to listen, but I think you may have answered this. In this 1927, this doesn't include teachers, or does it include?
It does. That number includes everyone who's under the state health plan.
But it only, it only includes those that gave birth, so it wouldn't
Yes.
include any foster family.
No, it doesn't include foster
Father.
families or anything like that. That is just the live births that were reported by Blue Cross Blue Shield. Of the 1927, it was actually 2,000 something, but there was 130 something where it was husband and wife that were married and from that. So there was a few extra, but this is the number of just females who gave a live birth under the state health plan.
And so major medical, that would include giving birth. Is that in that definition?
Yes.
But as far as, let's say, a father would that be included?
It is a qualifying event under FMLA
So
for either parent.
so it automatically qualifies for our
Yeah.
leave policies and things of that nature.
Yes.
So basically, a mother or, for that sake, an adopting parent or foster parent or whatever, in order to accrue enough personal leave, would have to work for the state. Of course, we're excluding schools.
Yeah.
For 1 year and 8 months before they would have enough time in order to have 6 weeks of paid leave once they're off.
On personal.
On personal.
A combination of the personal and medical, it's 1 year. If you were just doing the medical, it's 2 years and 6 months. Because of the way FMLA sets up, you can, and our system is set up for a qualifying event, you can use personal and medical leave for those.
And so is this just a straight 1 year and 8 months from the time they walk in the door at 1 year and 8 months, or 2 years and 6 months, or at the 1 year mark with both? This is just 1 year from when they walk in the door.
That's correct.
And because I didn't know if there was a pause time before they start accruing leave, but they start
No.
accruing from day one.
No, you accrue from day one.
And so after, let's say they've only worked there for a year, go out on maternity leave, part venture, they didn't use any of their days to do any of that. The day after they return, they would start accruing more hours to then, or how would that work?
No, they accrue during the time.
During
that
the
they're
time,
off.
okay.
Yeah. Once you start accruing, you accrue until you terminate, regardless of the leave that you take.
So arguably, if someone took 6 weeks off, they would come back with, let's see,
You'd come back with nearly 2 days.
2 days
of
already.
personal leave and you'd come back with nearly 3 days of leave while you were off. You would approximately accrue that much. It's that way, so a day and a half plus half of that, so it's 2.2 and then 1. So it's a little above 3 days that you accrued while you were off the 6 weeks.
and I'll, thank you, because that's what I was trying to figure out. And my concern was that even with this, that a parent, of course, would need to come back to work and then need to take off for appointments for the child, and need to take off for appointments for, themselves, to go to the doctor and all that kind of stuff. But they would return with almost 3 days.
Yes.
So, thank you. That's all the question that I have.
Senator, you got a question?
Kelly, this may be a little bit off, but I asked this yesterday. Since we're talking about leave and things like that, does the state, or have y'all looked at, or has the state looked at like a FSA type program? You know what I'm talking about?
Yes.
And the reason I'm thinking about it is because I don't know that anybody would have that amount of time, but they can use the FSA money that they do for various health things, and there's certain qualifying things. You could probably use them for your kids and things like that.
Yeah, under the state health insurance plan, there are options for them to be able to do that. And we'll allow the agency to whether they promote it or whether they don't promote it. We provide the agencies that information and the abilities to do that, but we don't mandate the agencies to do it, partly because and is from the reality is that some agencies get a lot of federal dollars to help with from the number of employees they got and what they can pay them versus those that are only getting state dollars. And on those how they want to set that up and how they want to offer it, we allow them to do that, but we will provide them with the information. Our role is kind of the clearinghouse to here's all the things you can do.
But if a state employee, depending on the agency,
Yeah.
they wanted an FSA, which for those, the way I'm defining it is they put money aside to use for family and
Yes.
health and stuff like that. The agencies can do that.
Yes, that under the state health and plan, they can encourage the individuals to do that if they wanted to do that. Yes.
Okay, thank you.
Yeah.
I know this happens in school. I think you said maybe it was Arkansas that put together like where somebody can donate 10 hours here or there. Can even currently, and this is outside of maternity leave, just as someone has a catastrophic event in their life and I think because FMA leave may go further than the time they have, can people donate across state like to this person or?
We have in the statute, there is a donated leave sections. People do use those donated leave. From our standpoint, the birth of a child isn't considered catastrophic. What considers catastrophic is health emergencies, cancers. I've got cancer, got a lot of stuff they do. I get hurt in a car wreck and I use up all my leave because I'm out 8 to 10 weeks and things of that nature. There are pools where you can agencies, their employees can donate to that individual. That is there.
I was asking outside the maternity leave thing.
Yes, it's for the whole gamut of, yeah.
Since you're here, I thought
Yeah.
I'd just ask a
Yeah.
question. But I think you said something. I just want to make sure. And you said like having a child wouldn't qualify as one of those events where people could donate.
It wasn't considered. It's not considered catastrophic.
Okay. And again, I was asking outside the maternity leave. I
Yeah.
just had you here, so I'd ask the question.
It can be devastating, but it's not catastrophic. Yeah. Thank you.